Introduction to business law. Business law, also known as commercial law, is a broad field encompassing the laws that govern business transactions and commercial activities. It regulates the rights, relations, and conduct of persons and businesses engaged in commerce, merchandising, trade, and sales. This legal framework is essential for establishing order, resolving disputes, and ensuring fair practices within the marketplace. It covers a wide array of legal areas, from the formation of companies to intellectual property rights. Understanding business law is crucial for any entrepreneur or manager to operate legally and ethically. For entrepreneurs, a solid grasp of business law is not merely beneficial but absolutely critical for long-term success and sustainability. It helps in making informed decisions, minimizing legal risks, and protecting business assets. Without this knowledge, businesses can inadvertently violate regulations, leading to costly lawsuits, fines, or even closure. It empowers business owners to structure their ventures correctly, negotiate contracts effectively, and manage their workforce in compliance with legal standards. Sources of business law. The primary sources of business law are diverse, reflecting the complex nature of commercial activities. Statutes and legislation enacted by legislative bodies form the bedrock of many business regulations. These laws provide specific rules for various aspects of business, such as company formation, consumer protection, and environmental standards. They are often codified, making them accessible and providing clarity on legal requirements. Examples include corporate acts, competition laws, and intellectual property statutes. Case law, also known as common law, is another significant source, derived from judicial decisions in specific cases. When courts interpret statutes or apply legal principles to new situations, their rulings create precedents that guide future decisions. This system ensures consistency and predictability in legal outcomes, as lower courts are generally bound by the decisions of higher courts. This dynamic interplay between statutory and case law continually shapes and refines the legal landscape for businesses. Legal entities. Sole proprietorships. A sole proprietorship is the simplest and most common form of business ownership, where an individual owns and operates the business. This structure is easy to establish, requiring minimal legal formalities and offering complete control to the owner. The owner and the business are legally inseparable, meaning there is no distinction between personal and business assets and liabilities. This personal liability is a significant characteristic, as the owner is personally responsible for all business debts and obligations. Profits are taxed as personal income, simplifying tax reporting. While offering simplicity and direct control, the unlimited personal liability of a sole proprietorship presents considerable risks. Business debts, lawsuits, or other financial obligations can directly impact the owner's personal assets, including homes and savings. This structure is often suitable for small businesses with low risk or those just starting out, due to its low setup cost and administrative burden. However, as a business grows and its risk profile increases, many sole proprietors consider transitioning to more complex legal structures to protect personal assets. Legal entities, partnerships. A partnership is a business structure where two or more individuals agree to share in the profits or losses of a business. This arrangement is typically formalized through a partnership agreement, which outlines each partner's contributions, responsibilities, and profit-sharing ratios. Partnerships combine the resources and expertise of multiple individuals, often leading to greater capital and diverse skill sets than a sole proprietorship. However, like sole proprietorships, general partnerships usually involve unlimited personal liability for all partners. Each partner can be held responsible for the debts and obligations of the business, including those incurred by other partners. There are different types of partnerships, including general partnerships, GPs, limited partnerships, LPs, and limited liability partnerships, LLPs. LPs have at least one general partner with unlimited liability and one or more limited partners whose liability is restricted to their investment. LLPs offer limited liability to all partners, protecting them from the debts and actions of other partners, making them a popular choice for professional services firms. The choice of partnership type depends on the desired level of liability protection and management involvement. Legal entities, corporations and LLCs. Corporations are distinct legal entities separate from their owners, offering shareholders limited liability. This means that the personal assets of shareholders are protected from the company's debts and liabilities, making it a highly attractive structure for businesses seeking to raise capital and grow. Corporations have a more complex structure, involving a board of directors, officers, and shareholders, and are subject to more rigorous regulatory requirements. They can issue shares to raise capital, and their existence is perpetual, independent of changes in ownership. Limited liability companies, LLCs, combine elements of both partnerships and corporations, offering limited liability to their owners, members, while providing pass-through taxation similar to a partnership. This hybrid structure is popular for its flexibility, allowing members to manage the company directly or appoint managers. LLCs are generally simpler to set up and operate than corporations, with fewer ongoing compliance requirements. They provide personal asset protection without the double taxation sometimes associated with corporations, making them a versatile choice for many small to medium-sized businesses. Introduction to labor law. Labor law, also known as employment law, is a critical branch of business law that governs the relationship between employers, employees, and trade unions. Its primary purpose is to protect the rights and interests of workers, ensuring fair treatment, safe working conditions, and equitable compensation. This body of law aims to balance the power dynamics between employers and employees, preventing exploitation and promoting harmonious industrial relations. It covers a wide range of issues, from hiring and firing to workplace safety and discrimination. Adherence to labor law is mandatory for all businesses, regardless of size or industry. The scope of labor law is extensive, encompassing various aspects of the employment life cycle. It dictates minimum wage standards, working hours, overtime pay, and leave entitlements. Furthermore, it addresses issues such as unfair dismissal, harassment, and discrimination based on factors like gender, race, religion, or disability. Collective bargaining, which involves negotiations between employers and trade unions, is also a significant component of labor law. Understanding and complying with these regulations is vital for businesses to avoid legal disputes, maintain a positive work environment, and uphold their social responsibilities. Employment contracts. An employment contract is a legally binding agreement between an employer and an employee, outlining the terms and conditions of employment. It establishes the rights and responsibilities of both parties, providing clarity and certainty regarding the working relationship. Key elements typically include the job title, duties, working hours, compensation, benefits, and duration of employment. While some contracts can be verbal, written agreements are highly recommended to prevent misunderstandings and provide clear evidence in case of disputes. A well-drafted contract protects both the employer and the employee. The formation of an employment contract requires an offer, acceptance, and consideration, similar to other types of contracts. The offer is made by the employee accepts it, and consideration usually involves the employee's work in exchange for the employer's remuneration. Contracts can be for a fixed term or indefinite, and they may include clauses related to confidentiality, non-compete agreements, and intellectual property ownership. Understanding these contractual elements is crucial for businesses to ensure compliance and for employees to know their rights and obligations from the outset of their engagement. Employee rights and responsibilities. Employees are entitled to fundamental rights that ensure fair and respectful treatment in the workplace. These rights typically include protection against discrimination based on characteristics such as race, gender, religion, age, or disability. They also encompass the right to a safe working environment, free from harassment and hazards, and the right to privacy. Furthermore, employees have rights regarding fair wages, reasonable working hours, and access to statutory benefits like paid leave, These protections are enshrined in various labor laws and aim to create an equitable and dignified work experience for all. Alongside their rights, employees also bear significant responsibilities towards their employer and the workplace. These responsibilities typically include performing assigned duties diligently and competently, adhering to company policies and procedures, and maintaining confidentiality of proprietary information. Employees are expected to act in the best interest of the business, maintain professionalism, and contribute positively to the work environment. Understanding and fulfilling these responsibilities is crucial for fostering a productive and harmonious relationship between employees and employers, ensuring the smooth operation of the business. Employer obligations. Employers have a comprehensive set of legal obligations designed to ensure the well-being and fair treatment of their workforce. A paramount obligation is to provide a safe and healthy working environment, free from recognized hazards, as mandated by occupational health and safety regulations. This includes implementing safety protocols, providing necessary training, and maintaining equipment. Employers must also comply with minimum wage laws, pay employees on time, and provide statutory benefits such as social security contributions and paid leave. These obligations are non-negotiable and form the bedrock of ethical employment practices. Beyond safety and compensation, employers are legally bound to prevent discrimination and harassment in the workplace. They must establish clear policies against such behaviors and provide avenues for employees to report concerns without fear of retaliation. Furthermore, employers have obligations regarding data privacy, protecting sensitive employee information. When terminating employment, employers must adhere to legal procedures, including providing adequate notice or severance pay to avoid claims of wrongful dismissal. Fulfilling these obligations is not only a legal requirement, but also crucial for fostering a productive and reputable business culture. Child labor laws. Child labor laws are designed to protect children from exploitation and ensure their right to education and a healthy development. These laws prohibit the employment of children below a certain age, typically 14 or 16, in most forms of work. The primary goal is to prevent children from being engaged in work that is detrimental to their physical, mental, or moral well-being. International conventions, such as those from the International Labour Organization, ILO, provide global standards for the elimination of child labor. Adherence to these laws is a fundamental human rights issue and a critical component of corporate social responsibility. The prohibitions extend to hazardous work for young persons above the minimum age, setting strict regulations on the types of tasks they can perform and the hours they can work. These regulations aim to protect adolescents from dangerous occupations that could injure them or jeopardize their health. Businesses found to be in violation of child labor laws face severe penalties, including hefty fines, imprisonment, and significant reputational damage. Therefore, it is imperative for all businesses to conduct thorough age verification and ensure full compliance with both national and international child labor standards. Exceptions for young workers. While child labor is generally prohibited, many jurisdictions allow for exceptions where young persons can engage in certain types of work under strict conditions. These exceptions typically apply to adolescents above the minimum age for general employment, often 14 or 16, and are designed to provide opportunities for vocational training or light work that does not interfere with their schooling or health. Permitted work often includes roles in retail, food service, or office administration, provided the tasks are non-hazardous and performed during limited hours. These regulations ensure that any work undertaken by young people is safe, educational, and supportive of their overall development. Specific protective measures are in place to safeguard young workers, even in permitted employment. These measures include restrictions on working hours, especially during school days and late at night, and limitations on the types of equipment they can operate. Employers are often required to obtain work permits for minors and adhere to strict supervision requirements. The aim is to prevent young workers from being exposed to dangerous environments or excessive workloads. Businesses must be diligent in understanding and implementing these specific regulations to ensure compliance and protect their younger employees. Law of Contract Fundamentals. The law of contract is a cornerstone of business law, governing agreements between parties that create mutual obligations enforceable by law. A valid contract requires several fundamental elements to be present. Firstly, there must be a clear offer made by one party, indicating a willingness to enter into an agreement on specific terms. Secondly, there must be an unequivocal acceptance of that offer by the other party, signifying their agreement to the proposed terms. This offer and acceptance together form the basis of mutual assent or a meeting of the minds. Thirdly, consideration is a crucial element, referring to something of value exchanged between the parties. This could be money, goods, services, or a promise to do or not do something. Consideration ensures that both parties are giving up something of value, making the agreement mutually beneficial and legally binding. Without valid consideration, an agreement is generally considered a gratuitous promise and is not enforceable as a contract. These three elements, offer, acceptance, and consideration, are indispensable for the formation of a legally binding contract in most jurisdictions. Law of contract. Validity. Beyond offer, acceptance, and consideration, a contract must possess several other elements to be legally valid and enforceable. Capacity refers to the legal ability of the parties to enter into a contract. Generally, individuals must be of legal age, typically 18, and possess sound mental capacity to form a binding agreement. Contracts entered into by minors or individuals deemed mentally incapacitated may be voidable. This ensures that all parties understand the implications of their agreement and are capable of giving genuine consent. Legality of purpose is another crucial aspect, meaning the contract's objective must be lawful. Agreements to perform illegal acts, such as committing a crime or violating public policy, are void and unenforceable. Furthermore, there must be a genuine intention to create legal relations. Casual social agreements are generally not considered legally binding contracts. The absence of duress, undue influence, or misrepresentation also contributes to a contract's validity, ensuring that consent is freely and genuinely given. These elements collectively safeguard the integrity and fairness of contractual agreements. Breach of contract and remedies. A breach of contract occurs when one party fails to fulfill their obligations as specified in a legally binding agreement. This failure can take various forms, such as non-performance, defective performance, or anticipatory breach, where a party indicates they will not perform before the due date. The type and severity of the breach determine the available legal remedies. A material breach, which goes to the core of the contract, often allows the non-breaching party to terminate the contract and seek damages. Understanding the nature of a breach is crucial for determining the appropriate legal response. When a contract is breached, the non-breaching party typically has several remedies available to them. The most common remedy is monetary damages, intended to compensate the injured party for their losses and place them in the position they would have been in had the contract been performed. Specific performance. A court order requiring the breaching party to fulfill their contractual obligations is another remedy, usually granted when monetary damages are inadequate, such as in contracts for unique goods or land. Other remedies include rescission, cancelling the contract, or injunctions prohibiting certain actions. These remedies aim to restore justice and enforce the terms of the agreement. Recruitment and contracting arrangements. The recruitment process involves a series of legal considerations that businesses must navigate to ensure fair and compliant hiring practices. From advertising job vacancies to conducting interviews and making offers, every step is subject to anti-discrimination laws. Employers must avoid asking discriminatory questions and ensure that selection criteria are job-related and non-biased. Background checks, reference checks, and drug testing must also comply with privacy laws and specific regulations. Adhering to these legal requirements helps businesses attract diverse talent and avoid costly legal challenges. Businesses often utilize various contracting arrangements, including hiring employees and engaging independent contractors. The distinction between these two categories is legally significant, impacting tax obligations, benefits, and liability. Employees are typically subject to an employer's control over how and when work is performed, while independent contractors retain more autonomy. Misclassifying a worker can lead to severe penalties, including back taxes, fines, and legal disputes. Therefore, businesses must carefully assess the nature of the working relationship and ensure proper classification to comply with labor and tax laws. Termination of employment. The termination of employment is a legally sensitive process that requires strict adherence to labor laws to avoid claims of wrongful dismissal. Employers must provide adequate notice periods or payment in lieu of notice, as stipulated in employment contracts or relevant legislation. The length of the notice period often depends on the employee's length of service and the terms of their contract. Failure to provide proper notice can result in legal action and significant financial penalties. It is crucial for businesses to understand and follow these requirements meticulously. Wrongful dismissal occurs when an employer terminates an employee without just cause or without adhering to proper legal procedures. Just cause typically refers to serious misconduct or fundamental breaches of contract by the employee. If an employer cannot demonstrate just cause, or if they fail to follow fair process, the dismissal may be deemed wrongful. Remedies for wrongful dismissal can include reinstatement, compensation for lost wages, and damages for emotional distress. Businesses should always seek legal advice when considering termination to ensure compliance and minimize legal risks. Law of sale, principles. The law of sale governs contracts for the sale of goods, establishing the rights and obligations of both buyers and sellers. A core principle is the transfer of ownership, where the title to the goods passes from the seller to the buyer, typically upon delivery or payment. This transfer of title is crucial as it determines who bears the risk of loss or damage to the goods. The law also addresses the formation of sales contracts, including offer, acceptance, and consideration, specifically tailored to transactions involving tangible items. Understanding these principles is vital for businesses engaged in buying and selling products. Implied conditions and warranties are fundamental aspects of the law of sale, providing protections to buyers even when not explicitly stated in the contract. Common implied conditions include that the seller has the right to sell the goods, that the goods correspond to their description, and that they are of satisfactory quality and fit for their intended purpose. Implied warranties, though often less stringent than conditions, also offer assurances regarding the goods' performance. These legal safeguards ensure that buyers receive what they reasonably expect, promoting fair trade and consumer confidence. Businesses must be aware of these implied terms to avoid liability. Law of sale, consumer protection. Consumer protection laws are a vital component of the law of sale, designed to safeguard the rights and interests of consumers against unfair business practices. These laws ensure that consumers receive accurate information about products and services, are protected from misleading advertising, and have recourse for faulty or unsafe goods. Key consumer rights include the right to safety, the right to be informed, the right to choose, and the right to be heard. Businesses must adhere strictly to these regulations to maintain consumer trust and avoid legal penalties. Product liability is a significant area within consumer protection, holding manufacturers, distributors, and retailers responsible for injuries or damages caused by defective products. This liability can arise from manufacturing defects, design defects, or inadequate warnings. Consumers who suffer harm due to a faulty product can seek compensation, even if they did not directly purchase the item. Businesses must implement rigorous quality control measures and provide clear instructions and warnings to mitigate product liability risks. Compliance with these laws is essential for both legal and ethical business operations. Law of lease, commercial leases. Commercial leases are legally binding contracts between landlords and tenants for the rental of property for business purposes. Unlike residential leases, Commercial leases are often more complex and less regulated, allowing for greater negotiation between parties. Key elements typically include the duration of the lease, rent amount, maintenance responsibilities, and provisions for renewal or termination. Businesses entering into commercial leases must carefully review all terms and conditions, as they can significantly impact operational costs and long-term business stability. Legal advice is highly recommended before signing such agreements. Landlords and tenants in commercial lease agreements have distinct rights and responsibilities. Landlords typically have the right to receive rent, enforce lease terms, and repossess the property upon breach. Tenants have the right to quiet enjoyment of the premises, meaning they can use the property without undue interference from the landlord. Responsibilities often include the tenant maintaining the interior and paying utilities, while the landlord maintains the exterior and structural integrity. Understanding these rights and responsibilities is crucial for both parties to avoid disputes and ensure a smooth tenancy, which is vital for business continuity. Law of lease. Residential leases. Residential leases are agreements for the rental of property for living purposes, governed by specific laws designed to protect tenants. These laws often provide greater protections to tenants than commercial lease laws, recognizing the fundamental need for housing. Key provisions typically include limits on security deposits, requirements for habitable living conditions, and procedures for repairs. Landlords have an obligation to provide a safe and livable environment, free from health and safety hazards. Understanding these tenant protections is crucial for both landlords and tenants to ensure compliance and fair treatment. Eviction procedures are strictly regulated in residential lease law, requiring landlords to follow specific legal steps to remove a tenant. Landlords typically must provide proper notice, often in writing, and have a valid legal reason for eviction, such as non-payment of rent or violation of lease terms. Tenants have rights to due process, including the opportunity to remedy breaches or present their case in court. Illegal evictions, such as changing locks or shutting off utilities without a court order, are strictly prohibited and can result in severe penalties for landlords. Adherence to these procedures is essential to protect tenant rights and avoid legal disputes. Law of agency, creation and authority. The law of agency governs the relationship where one person, the agent, acts on behalf of another, the principal, creating legal relations with third parties. This relationship is typically formed through an agreement, either express or implied, where the principal grants the agent authority to act. The agent's actions within the scope of their authority bind the principal, making the principal legally responsible for the agent's commitments. This legal framework is fundamental in business, allowing individuals and organizations to expand their reach and conduct transactions through representatives. An agent's authority can be categorized in several types. Actual authority, which can be explicitly stated, or implied, arising from the agent's position or custom, is directly granted by the principal. Apparent authority arises when the principal's words or conduct lead a third party to reasonably believe that the agent has authority, even if they do not. This protects third parties who rely in good faith on the agent's perceived authority. Understanding these distinctions is crucial for businesses to properly empower their representatives and manage their legal liabilities arising from agency relationships. Law of agency, duties and liabilities. Agents owe several fiduciary duties to their principals, which are obligations of trust and loyalty. These duties include acting in the principal's best interest, avoiding conflicts of interest, and maintaining confidentiality of the principal's information. Agents must also exercise reasonable care and skill in performing their duties and account for all money or property received on the principal's behalf. Failure to uphold these duties can result in the agent being held liable for damages suffered by the principal. These duties ensure that the agent acts faithfully and responsibly. The liability of principals and agents to third parties is a critical aspect of agency law. Generally, if an agent acts within their actual or apparent authority, the principal is bound by the agent's actions and is liable to the third party. The agent typically is not liable to the third party if they disclose their principal's identity. However, if an agent acts outside their authority or fails to disclose the principal, they may be personally liable. Understanding these complex liability rules is essential for businesses to manage risks associated with their agents' actions and protect themselves from unforeseen legal consequences. Business governance, corporate structure. Business governance refers to the system of rules, practices, and processes by which a company is directed and controlled. It encompasses the relationship between a company's management, its board of directors, shareholders, and other stakeholders. Effective governance ensures accountability, transparency, and fairness in a company's operations, promoting long-term success and sustainability. It defines the distribution of rights and responsibilities among different participants in the corporation, such as the board, managers, and shareholders. Good governance is crucial for attracting investors and maintaining public trust. The corporate structure typically involves a board of directors, elected by shareholders, responsible for overseeing the company's strategic direction and management. Shareholders, as owners, have rights to vote on major corporate decisions and elect directors. Officers, appointed by the board, manage the day-to-day operations. This hierarchical structure ensures checks and balances, preventing undue concentration of power and protecting the interests of all stakeholders. Understanding this structure is fundamental for anyone involved in corporate management or investments, as it dictates decision-making processes and accountability. Environmental law. Regulations. Environmental law is a body of law that regulates human interaction with the natural environment to reduce impacts and protect natural resources. Its primary goal is to prevent pollution, conserve biodiversity, and promote sustainable practices. Businesses are subject to a wide array of environmental regulations, including those related to air and water quality, waste management, and hazardous substances. Compliance with these laws is not only a legal obligation, but also a critical aspect of corporate social responsibility. Failure to comply can lead to significant fines, legal action, and reputational damage. Pollution control regulations are a major component of environmental law, setting limits on emissions into the air, discharges into water bodies, and the disposal of waste. Businesses must obtain permits for certain activities and monitor their environmental impact to ensure they meet regulatory standards. Waste management laws dictate how various types of waste, especially hazardous waste, must be handled, stored, transported, and disposed of. These regulations are constantly evolving, requiring businesses to stay informed and adapt their operations to new legal requirements. Proactive environmental management is key to avoiding legal pitfalls and contributing to a healthier planet. Environmental law, corporate responsibility. Corporate environmental responsibility extends beyond mere compliance with regulations. It involves a proactive commitment to minimizing environmental impact and promoting sustainable practices. Many businesses conduct environmental impact assessments, EIAs, before undertaking new projects to identify and mitigate potential environmental harm. These assessments evaluate the project's effects on air, water, soil, biodiversity, and human health, guiding decisions to reduce negative impacts. Integrating environmental considerations into business strategy is becoming increasingly important for reputation and long-term viability. Sustainability practices are at the heart of modern corporate environmental responsibility. This includes adopting renewable energy sources, reducing waste through recycling and circular economy models, and sourcing materials ethically. Businesses are increasingly expected to report on their environmental performance, demonstrating transparency and accountability to stakeholders. Embracing sustainability not only helps meet legal and ethical obligations, but can also lead to cost savings, enhanced brand image, and competitive advantages. It represents a shift from simply avoiding harm to actively contributing to environmental well-being. Intellectual property law. Overview. Intellectual property (IP) law protects creations of the mind, granting exclusive rights to creators over their inventions, literary and artistic works, designs, and symbols used in commerce. This legal framework encourages innovation and creativity by allowing creators to benefit from their work. IP is a critical asset for many businesses, providing a competitive edge and a source of revenue. It encompasses several distinct categories, each with its own set of rules and protections. Understanding these categories is essential for businesses to protect their innovations and creative works. The main categories of intellectual property include patents, trademarks, and copyright. Patents protect inventions, granting the inventor exclusive rights to make, use, and sell their invention for a specified period. Trademarks protect brand names, logos, and slogans, distinguishing goods and services of one business from another. Copyright protects original literary, dramatic, musical, and artistic works, including software and architectural designs. Each type of IP serves a unique purpose in safeguarding different forms of creative and innovative output, allowing businesses to leverage their intellectual assets effectively.